So in oh for fuck's sakes news, and not in the sarcastic, like this is a really quirky story, oh for fuck's sakes, but oh for fuck's sakes, what the heck was this judge thinking? So this is out of King County, Washington. If you recall the story out of Falls City where the 15-year-old killed all of his family except for his 11-year-old sister, a King County judge decided to let the defense go to the house unescorted by anybody from the King County Sheriff's Department. And of course, now the prosecution is saying that some things were moved and things may be missing. So the headline says, defense team accused of altering crime scene of Fall City murders. So this gives a background on the story about how the boy was accused of killing his parents as well as his younger siblings, who were 13, 9, and 7. And then it says, and they quote the senior deputy prosecuting attorney as saying that it's clear the defense counsel and their agents exceeded the permitted scope of their search under the court's order. The boys' attorneys had access to the house on October 29th, one day after Judge Veronica Galvin granted their motion to enter the home without supervision by the sheriff's office. Galvin gave 4 members of the defense team a 10-hour window to take pictures and conduct a 3D scan inside the home, as well as search the boys' bedroom. The order prohibited the attorneys from removing items from the home or searching through file cabinets, containers, drawers, digital devices, and the like. The defense team may only view items that are in plain view, Galvin wrote in the order. King County Sheriff's Office documented the home before and after the defense team's access, according to the prosecution's memo. The memo alleges a bottle of Clorox wipes from the home is missing and backpacks belonging to the child victims were opened or moved. The prosecutor's office is seeking an order to compel the defense to turn over all the material they collected during their time in the house. The state is particularly interested in those materials obtained on October 29th because King County Sheriff's Office was not permitted to observe defense counsel or their agents as they spent hours in the residence. And a comparison of the photographs taken in the front entryway of the residence, as well as from the boys' and girls' rooms before and after their presence there, suggests that they exceeded the scope, certification, and motion to compel discovery committed by the court's order. Brookshire wrote, the state is entitled to possession of those materials in the due course of counsel's reciprocal discovery obligations, and the court should also have access to those materials in order to properly determine whether counsel complied with the presumption that they would behave as officers of the court when granted unmonitored access to the scene. That's just unbelievable. And the article also states that the defense had already been in the house previously, but they had a sheriff's escort the first time they went in. I just think that is nuts that any judge would allow them access without somebody from the sheriff's department there with them to make sure they weren't taking any evidence. That it's just ridiculous to me, but I'm used to it. These judges out here in Washington, like if you think some of the liberal judges in New York and places like that are nuts, the judges out here are like, hold my beer. They are so soft on crime, it's not even funny. And I understand this is a 15-year-old, and there's probably a lot of emotions about this case, and they're trying to try him, they're working on trying him as an adult, but still, I mean, for a judge to make a decision like that, and it did say that the 2 attorneys left the case right after this happened. So they dropped the 15-year-old as their, defendant, and he has a new attorney now. But what's more frustrating is I understand that an attorney has a duty to their client, and yes, they have to defend them, but the 15-year-old is still trying to claim his 13-year-old brother committed the crimes. And his defense attorney is basically trying to uphold that version. So, sheriff's report says the 11-year-old girl, that's the survivor, saw her 15-year-old brother shoot her and then saw him touching the necks and chests of other family members to see if they were alive. The girl later told detectives that her 15-year-old brother was the only one of the siblings who knew the combination to the gun safe in the home. While the 15-year-old claimed his deceased brother had killed the family, then killed himself, investigators said the 13-year-old boy died from multiple gunshot wounds that were fired from farther away than 2 feet. According to the charges, one of the shots that killed the 13-year-old entered from the back of his head, according to an autopsy report, which listed the manner of death as homicide. Defense attorneys, however, claim the 15-year-old boy's versions of the event are forensically viable. The state's theory is that a 15-year-old was involved in a mass killing of 5 people with firearms confined to a basement, defense attorney Amy Parker wrote in a motion to preserve evidence. There is no evidence at this point that we have received that indicates the 15-year-old had any blood on him. Parker's motion was filed on October 28th when there was a second visit to the home and without the supervision of the sheriff's office. Oh, so there was actually 2, because I know there had been another visit to the home when the sheriffs were there. So we had 2 without supervision. That's just great. It is my experience that law enforcement can and does engage in biased investigations when they think they have their right suspect, Parker wrote. In my experience, it is beneficial for the defense to have an opportunity to investigate the crime scene, in this case, free from bias. Prosecutors and an attorney for Sarah Humiston's mother opposed the defense having access to the house in the first place. Wow. That's stunning. I'm sorry, but so they've been to visit twice without supervision from the sheriff's department, and the attorney thinks that he didn't do it, that it's viable that the 13-year-old brother who was shot in the back of the head somehow did it. This whole thing is heartbreaking, and that sister that survived, all my thoughts and prayers are with her. And what an awful situation all the way around. And it's just frustrating when you have judges that act like this, that don't have any respect for the victims. I don't know. It's just a frustrating case all the way around. And doesn't surprise me, though. That's what I've come to expect from the judges in Washington State. But I just hope that the girl that survived is able to get some sort of justice. My heart goes out to her.